Hello, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our every other Thursday bi-weekly community conference call, which we have been holding for over 20 years, wherein we try to answer your questions to the best of our ability. Remember that when you logged into the conference, certain disclaimers were played for you, and we are all subject to the same conditions. No attorney-client relationship information being given to the best of our ability without any guarantee or warranty. I'm going to read over questions first that I have marked as frequently asked questions. I'll answer those first, and then I'll serially answer other questions that have been posted. If at any time during my questions you feel you have a follow-up question, no new question, a follow-up question to what I have discussed, feel free to raise your hand. You raise your hand in the system by pressing *5 on your phone. So if you press *5, I can see a raised hand. With that, let's begin. Today is March 3rd, 2022. Let's begin by going to the first frequently asked question. Abandonment. Can I leave the United States while a change of status is pending? And then further stamping requirements. So this is an important concept to understand. Normally, if you leave the United States while a change of status is pending, you are deemed to have abandoned the change of status, although you may not have abandoned the main application. Let me explain to you how that works. So let's say you are on a student status, F1. You applied for H1 under the lottery, and you applied for a change of status that I want to be converted from F1 to H1. But before the application could be decided, you had to leave the United States. Let's say you had an emergency, or you won a lottery for which you had to be in India just to sign some papers. If you leave in such a circumstance, the government will approve your H1, but they will not give you a change of status, since you left the country while the change of status request was pending. It's the same for other change of statuses such as L1, L2, H1, H4 to B1, which is tourist visa, B1, B2. If you leave during a change of status request, your application for change of status is abandoned. In some cases, if you leave during an extension, your extension request is deemed abandoned. For example, if you filed for a tourist status extension and you left the United States, that request is deemed to have been abandoned. That may not be true for visas like H1, etc., where there is no harm caused to your request. Okay? So the question that we have in front of us right now is this. I am on L2. It's going to expire in May. My company is going to file my Canadian visa in a month. Spouse is on L1A. Employer is going to file her green card soon. And she wants to stay with our kids until a decision is made. And she wants to stay as a visitor on the basis of green card filing. So the first problem I see here is when you have a green card going on after the I-140 has been filed, getting into a tourist status may be very difficult because you have exhibited immigrant intent. It's not a problem for L1, L2, H1, H4, but that immigrant intent is a problem for statuses like student or tourist. Okay, so she wants to stay back on tourist status, and as I indicated to you, that may be difficult with a green card pending. I want to apply for a change of status from L2 visa to visitor visa while I'm in the US. Well, strictly, it's not a visa, it's actually a change of status. Status and visa are two different things. Visa is something you get stamped at the US consulates outside the United States. That's your passport stamp, right? So I'm going to see my parents, etc. So is it okay to leave the US while my change of status from L2 to visitor visa is in the process? Now, in this case, it should be okay. But remember, I want you to Google something called Immigration and Nationality Act, Section 222G. I won't get into the details. It's a fairly complicated discussion. But while it is possible to do so, and it may not be a big problem, but they will not, USCIS will consider this to be abandoned. Okay? Another thing you need to remember is, in order for you to get a B2 visa stamp or a B1 visa stamp at the consulate, you do not need any kind of approval from the USCIS. So let's say you are on L2 and you want to just travel to India without applying for a B1, B2 application. You can do that. And while in India, you can request, go to the consulate and get a B1, B2 stamp. That's perfectly acceptable. But applying for a visitor status, I'm not sure whether it's needed or necessary for you. So the question, is it okay to leave? And the answer is yes, but the application will be deemed abandoned. They won't continue to process this, and you don't really need an approval from the USCIS. If you have a follow-up question on this, go ahead and press *5 on your phone. No new questions, only follow-ups. Okay, I will go on to the next frequently asked question, which is relation between F1 status and I-485 AOS. Okay, this is another very weird situation. Very weird. I'll tell you what happens. So normally, when you apply for a green card while you're on student status, it can be said that your student status is no longer in existence because you exhibited immigrant intent by filing I-140 or 485. USCIS has said, I've seen this in their policy statements from time to time, they have said that while H1L1, H4L2 type visas can coexist with an adjustment of status, F1 cannot. Okay, so we understand that. But the question that I have for the USCIS, which has never been answered, is this. What happens if I file an adjustment of status while I'm on F1? Does my F1 get voided immediately, automatically? And the answer is absolutely not. So the government has created an uneasy situation where we know that these two applications are not mutually compatible, but it really has no consequences. So the net result is, if you are going to school, I tell people to continue going to school. You can even go to school on a 485 pending application also. But I think even using an F1 during that time is okay, because the government has never quite told us what happens when we have both these applications pending. So in this case, what has happened is, son filed for F1 adjustment of status because he's aged out. The rest of the family, in April, my wife's son and I received the green card EAD cards. So the whole family, including the F1 holding son, have received their EAD. In August 21, the final action date became current for me, and my son became 21 and should be covered under CSPA. Well, that's a big jump. I don't know if he's covered or not, because it's final action dates or dates for filing. Final action date. Okay, so the final action date became current before he turned 21. Then he's covered. Okay, so I'm not getting into that, but let's say he's covered under CSPA. Your son is a senior in college with industrial engineering major. Does F1 approval mean he's no longer under green card EAD? No. So if he gets his F1 approval, that does not mean that his green card EAD has in any way been affected. Should he choose F1 or EAD? Absolutely EAD. the choices on EAD are a lot vaster. So my recommendation would be to just use the green card EAD. Yeah, and you can't do interfiling because then your son would lose his CSPA protection. Can my son choose to apply for OPT? Since you already have the green card EAD, I don't see the point of it, really, sir or ma'am. *5 if you have a follow-up question. So I would just go with the green card EAD as the better basis for employment. Okay, this one is from area code 805. 805, where are you calling from?
I'm calling from Chicago.
Okay, sir, go ahead. What is your question?
Yeah, sure. Yeah, my son turned 21 in August of last year. By then, his H4 also had expired. They used the date of birth for that. But then he had filed for his change of status to F1 before that. And also he got the green card EAD also. So from being in legal status point of view, is he okay?
This is the same question that I just discussed with just different dates. So, like I said, it's an uneasy partnership between F1 and adjustment of status I-485 application. I believe that he would continue to have good F1 status if he's maintaining status, as well as authorized period of stay under the filed I-485. So he's actually protected from two different angles. Okay. But if I were to be given a choice between using an OPT, STEM OPT, etc., and a green card EAD, I would always take green card EAD. It is a lot freer. And remember, with the green card EAD, he can work in his own field. He can work in a slightly different field. He can take 10 jobs. He can start his own business. He can do whatever he wants. Okay?
Okay. Yeah.
Good luck.
Thank you.
You are welcome. So let's go on to the next frequently asked question. Okay, this one, I don't know what this means. Relation between F1 OPT and H1B lottery, change of status, and changing employers. Okay, let's see. I'm a student on F1, graduating in December this year. Company A is applying for H1B. I'm interviewing with other companies and planning to drop Company A as soon as I graduate, which is December. If I'm selected in the lottery and haven't done a change of status, can I continue on F1 OPT with the other company, not Company A, after graduation? So, okay, first of all, what they are doing is, if you are on OPT, you have to coordinate with your DSO in the school. Typically, when you apply for a change of status with the H1B, the DSO steps in and basically deactivates your service account. Okay, so just make sure if that account is not deactivated, then you should be able to continue with your OPT with another company. So one way to do it is to file the H1B with counselor processing request rather than requesting change of status. And when you typically have a counselor request, the DSO should not deactivate your service. Sometimes they do it by mistake, but they are required to or recommended to do it only if you have filed for a change of status, which means give me H1 within the United States. So if you file it as a counselor processing, you can continue working on F1 OPT for that company or another company. Is H1 for me to keep and do a change of status later for another company? I don't know what that means. If you are on the call, press *5 because I don't understand this question. is H1 for me to keep and do a change of status later for another company? Don't know what that means. Can company A retract my H1B if I leave them? Absolutely. Not only can, but they should. That's pretty much the law. Being on F1, can company A start my green card if I win the H1B lottery? That depends upon which country you were born in. If you were born in India, that's not such a great deal. I actually have an article on this, a comment on this, on my author page in the Economic Times. So if you Google Rajiv S. Khanna, or Khanna as they say in this country, the Economic Times, it'll bring you to that page. And I have a comment there about how and when to file a green card while you are still a student. But the short answer is, for people born in India, it's usually not such a great deal. Okay. *5 if you have a follow-up question. Press *5 on your phone if you have a follow-up question. No new questions, anything to follow up. Okay. So this is Payalji has been in touch with me. I gave her the same answer, so I guess she was not satisfied. So I'll do it again. Question is, if a doctor is doing externship or observership, where he or she is not getting paid, is getting no monetary benefits in cash or in kind, okay, and is not involved in any kind of clinical care, I see no reason for them to think that's unauthorized employment. And many years ago, almost 25 years ago, if you had asked me, the law says that unauthorized employment is employment for remuneration or any other benefits. Maybe benefits also mean the experience that you are getting. Okay. I don't think that's a good interpretation of the law. Unless money changes hands, in cash or in kind, it is not unauthorized employment. I absolutely disagree with that. According to the DSO of the University of Pittsburgh, a researcher lab technician, even if they do an unpaid job, would not be considered a volunteer job. And the answer is, that's the school policy. That's not the definition of unauthorized employment. Okay? And that is also a policy that is typical of F1 status. It has no bearing on F2 status. Okay? So therefore, while the DSO is correct, but the fact that an F1 student can't even do an internship, I believe, is a matter of school policy, and it's actually only applicable to F1 students. Okay? I do not consider this to be a violation of law. *5 if you have a follow-up question. Press *5. There are other issues in volunteering, but that's the employer's problem, not yours. Normally, for-profit employers cannot take free work from people except under certain circumstances. So you don't need to worry about that. That's the employer's problem. Personally, I don't see any problem with it. Another frequently asked question, can parents of US citizens travel to the United States on an existing B2 visa while their green card is pending? And the answer is yes, but. So what is the yes? Yeah, normally the Customs and Border Protection people don't hassle the parents or spouses of US citizens too much, as long as they are not entering to adjust to green card status within the United States. So if the trip is indeed for visiting, normally they don't bother you. But can they if you have a green card pending? And the answer is yes. That's the but part. The yes is, I see no issue with trying. The bad part is, if a CBP officer is either ill-informed or particularly unnecessarily harsh, they could stop you and say, no, you go back. But I've found a practical solution to it, which I have recommended to many people. What I suggest is, for example, if you are coming from India, tell your parents to take a flight that does immigration pre-clearance in Abu Dhabi. That way, if they are denied entry, they just return from Abu Dhabi. They don't have to come all the way to the United States. If you are coming from Europe, you could do pre-clearance of immigration in Ireland. So I think there are a few, like less than 10 pre-clearance centers all over the world. You can Google them and find out which ones are the most convenient for you. Okay, so can they be stopped? Yes. Will they be stopped? Very unlikely. *5 if you have a follow-up question. *5. Okay, let's go on to the next frequently asked question. There was a question here about some kind of benefits, and I cannot really answer that question. There are two components to it. One is I don't know the exact facts of the case, and two, I'm going to have to review the law. I can't just offer an opinion without reviewing the law, and I won't have time to review the law for the community. Whatever I know off the top of my head, I'm happy to share, but I may not have time to review everything. So what should you do? Get yourself a lawyer, get them to give you an answer based upon a review of the law as well as the facts of the program. Okay. So now let's go back to the non-frequently asked questions. This is question number 3. Green card or citizenship for non-citizen parents using a state's paid leave program. I'm on H1B, having a baby. I need to take leave under the CTPL program. I don't know what that means. That's the question I just answered. So I don't really know what's going on. But I'll tell you this, that there are two things that are not a problem. So when you take usual maternity leave and normal maternity leave, that does not affect your H1B. Whatever is allowed, 6 weeks, 8 weeks, 10 weeks, whatever is allowed. I don't know what the law on that is. That's perfectly okay. And sometimes you can have a medical reason. For example, the doctor says, before the pregnancy, you have to rest a few weeks, bed rest. That's okay too, if you have a medical reason for it. I actually converted somebody from H1 to H4 after she had been out of work for over a year, because we had evidence that she had been in and out of hospitals during that whole year. So she did not have to maintain status because of medical reasons. Okay. Next question is it legal to give your child a different last name other than parents? It's okay to call your child, I don't know, Batman, Superman Smith. This is a free country. You can call your child anything you want. Under immigration law, there is absolutely no issue. Okay. I don't see any problems legally, but that's not really my field. I can only comment about immigration law. Under immigration law, zero problem. I don't see any issue here. *5 if you have a follow-up question. Okay. Question number 5. In the US, continuously on H4 to F1 and back to H1, need to travel internationally. Any issues getting H1 stamp? See, you were only 7-year-old when you came to the United States, Subbu. The fact that you've lived here so long, I don't see it as a problem at all. As long as other things are okay with your H1B, the fact that you've been here that long should not be a problem. Okay? I don't see any issue in that respect. *5 if you have a follow-up question. Okay. Then we come to H1B visa stamping. This is question number 6. H1B visa stamping under waivers of the interview and dropbox requirements. So I don't know the answer to this question. You got your F1 visa from Mumbai. Is it fine to get my H1B stamped from a dropbox in Delhi? As far as I know, US consulates in India don't have this policy that you're stuck with a particular consulate, but I think the easiest thing to do is just send New Delhi an email and they do respond to emails. Personally, I don't think it should be a problem. Okay. *5. If you have a follow-up question on this, press *5. Wow, none of the question posters are here. Then question number 8 is options for a child covered under CSPA. F1 applied for my daughter in December 2020. She's turning 21 this October. She'll be graduating in June this year. AOS filed for my daughter in EB3 in August last year when the dates become current. F1 approved, so technically she's now on F1. Received green card EAD, my EB2 dates are current. I'm in the process of applying a fresh EB2. Am I correct in assuming that we can file EB2 AS for my daughter even though she's on F1? Well, look, as long as she's under 21, which she is, right? And if your dates are current, you should be able to file for an adjustment of status even though she is an F1. Can she use F1 OPT? I believe so. I know other people in the same situation. I do not know any reason why she cannot. Would this be confusing? She would have EB3 AOS, EB2 AOS, and also OPT EAD. I don't see why it should be a problem. But if you already have an EAD, why do you need to apply for her EAD through OPT, etc.? I already covered that issue. In my view, the EAD that comes with the green card is a much better option for most people. *5. If you have a follow-up question on this, press *5. Oh, this one is from California. California, go ahead, please.
Yeah, hey, thanks, Rajiv ji. I think I've learned a lot from your community call.
Oh, good.
I heard your suggestion before. The only reason to do OPT or even try for an H1 is just as a backup option, nothing else. That's
no,
the
then go for the H1 directly. Why go into OPT? Just keep applying for H1 every year, starting whenever she graduates.
Okay. All right, sounds good.
One more piece of information. Remember that she can apply for the lottery even if the degree is not yet completed. As long as the degree is completed by the time she applies for the H1B, she's okay. So you don't need a finished degree to apply for lottery. Go ahead with the other questions.
All right. Yeah, thanks. I got that. Yeah, okay. The other question is, since we decided not to do interfiling and I'm in the process of doing the EB2 AOS now that my dates are current, we are only planning to do EB2 AOS, I mean not the EAD AP. Like typically, how does these multiple applications work? Like once either one of them gets approved or one automatically gets rejected, or how does this work?
No one really quite knows. We have a bunch of them. Sometimes I just don't want to take a risk with anything. I'll file double applications. Normally, these two things happen. Normally, we've been getting EADs, advanced paroles, only in one application. And somewhere where if both dates become current, EB3 and EB2, they'll ask me to pick one or the other 485 and ask me to withdraw one of them. But if EB3 date becomes current, they'll just adjudicate it and the other one is automatically moot because you already have a green card. Okay.
Okay. Got it. And then does it even make sense to then do an EAD AP for the new EB2 as well?
I would.
Do 485 for EB2 and 20?
I would do it. I would do it.
So,
okay.
Oh, okay. So we should do that. So then later on, if I change job, then I have to do 485J for both the applications, right? EB2 as well as EB3.
Yes, you would. If you are using AC21, yes, you would. Okay.
Okay. Excellent.
Good luck.
All right. Thank you.
All right. Bye-bye. Okay. Then we come to, let's see. Well, already we've done all these. Am I eligible? This is question number 12. Am I eligible for H1B cap exempt if I was selected in 2018? And the answer is yes. Okay. It was approved only for 3 months, so I did not go for stamping. So the answer is yes, you should be lottery exempt. It is certainly worth looking into. There are some issues about if you haven't gotten a change of status or a visa. USCIS sometimes claims you are still not protected from the quota. You're still subject to the cap. But I've never had a problem. We have filed many cases like this. Remember, at least till 2024, which is 6 years from the date you got approved, you should be okay to try and get quota exemption, cap exemption. *5, if you have a follow-up question, *5. Okay. So, the 13th question is, my fiancé and I have known each other for the past 11 years. Decided to get married. Congratulations. He's an Indian citizen, lives in UAE. I'm a US citizen. Should we apply for a fiancé visa? Should we marry in UAE? Yeah, I like the option of a fiancé visa better. Okay. I don't have any average times for you, nor can I give them to you, because I can tell you this, that the green card should certainly take a lot longer than a K1. Can he study when he arrives on a fiancé visa? If you go to the USCIS website, under student status, they have they have created a table which tells you exactly what you can do in terms of going to school in each status. You can double check with the DSO of a school. To the best of my knowledge, a fiancé visa holder can study in the United States. Okay. There's another option called K4 visa, like K3, which is available for the spouses of US citizens. So when you are already married, you apply for K3 along with the green card. So that's something to consider. That might be another combo you can look into. But my hope is that K1 would be the fastest for you. *5, if you have a follow-up question on this. Okay. So this is the last question, and then we can start with new questions. Last question is, what happens when the priority date becomes current? I have an I-140 approved. I moved back to India, still with the same employer. My date became current. Is there a time limit within which we should file I-485? When you're outside the United States, I don't see any such time limit. Can I apply for consular processing after 2 years of my PD becoming current? Yes, absolutely. You do need support from your employer. You cannot do it yourself. You can pay a lawyer yourself. That's not a problem. But you can't do this without a genuine job offer. Okay? *5, if you have a follow-up question on this, press *5. There being none, oh, there is one from California. Okay. Yeah, California, go ahead, please.
Thank you for the community call, sir. I have one other question about the timeline. So if I apply for consular processing, will that be in months or will it take longer, sir?
Couple of years, I would think, because first you have to file a form, I forget its name, the form that's called request for action on an approved petition. Basically, if you had earlier filed your I-140 indicating on it that you're going to do adjustment of status, and now you want to convert it to consular, it'll go through an extra hoop. That could take 7-8 months. After that, the green card process going through the consular processing can be a year and a half easily. So you're looking at a couple of years, I would say. Okay.
So will I be eligible for L1 visa also?
In the meantime, oh, absolutely. Absolutely. Look, if you are eligible for L1A, then I would want you to come to the United States on L1A and apply for adjustment of status using EB1C category. Okay. That way, yeah, it's all clean. So good luck to you, sir.
Thank you.
You're welcome. Okay, so anybody has any question, please press *5 on your phone. Anyone has any question, please press *5 on your phone. Okay, so this one is Google Meet from area code 617. Whoever is calling from Google Meet, go ahead. I can hear you.
Yeah. Hi, Rajiv. So I have a doubt. I am applying for my F1 visa. I got an admit, but my company is also filing for my H1B.
Okay.
Would it cause any issue during F1 visa interview if I don't get selected in the lottery?
Well, that doesn't come up, you see. That does not come up during the interview.
Okay.
Because there's no question, have you ever applied for a lottery? There's no question, have you ever applied for an H1 status? Okay?
Okay, and what if my lottery gets picked and I go for F1 interview anyway?
There's still no question about that.
That doesn't...
There is no question about that. But my only recommendation would be, if by some chance you get asked that question, which I cannot believe it would be, just answer truthfully. Don't ever try to protect yourself by creating stories. Just tell the truth. Okay?
Okay.
Good luck.
Okay, and wouldn't that cause any issues with
that? I don't know. I can't tell you. I would have to be a future seer to give you that answer. But I know what the right thing to do is. Okay?
Okay, got it.
Good luck, sir.
Thanks, Rajiv.
You're welcome. I think next one is from New York. New York, go ahead, please. Area code 212.
Hello, sir. This is Hello, sir. How are you?
Good, sir.
This is regarding my parents for the B2 visa. They are in India. I'm planning to apply for the interview waiver program in Delhi, dropbox. 10 years ago, first their B2 got rejected and immediately applied and they got the visa.
Okay, hang on. Yeah, they are eligible. They are eligible because the policy says you are not eligible if you have a denial, but if the denial was later approved, then you are still eligible.
Okay, sir. And I have a follow-up question on it. While booking the appointment in the US travel doc, the profile's first name was typo error, and in D160 we did not submit it. We are going to submit it. Is that going to have a problem?
I do not know. I do not know. Read the frequently asked questions that the consulate has posted. The answer is there. I remember reading it, but I don't remember what the answer was. Okay. Good luck.
Okay, sir. Thank you very much.
You're welcome.
You're
welcome, sir. Area code 903. Where are you calling from? Area code 903.
Texas, sir.
Okay, Texas. Go ahead, please.
So I have a question about my adjustment of status application. So it was filed in October 2020.
Okay.
Under EB3.
Okay.
For the downgrade from EB2 to EB3.
Okay.
And it's still pending.
Okay.
And now I'm changing my employers. And the employer which I'm changing to, I have worked with them in the past. And they have my EB2 I-140 approved. So they are asking me to do an interfile because USCIS has issued the guidance of doing interfiling because EB2 has more visas available.
Yeah, I think that should be fine. But there are other issues that you should discuss with your lawyers. I won't have time to even touch on all those issues. The 2 or 3 main issues are, first of all, if this company had an I-140 for you, why did you leave? It's supposed to be a permanent job. And 2, if it's supposed to be a permanent job, who's doing that job while you are gone? Why did the company hold the position open for you? There's some of the things that you need to look into. They may not be serious issues, but they should be planned, understood, and only then you should take all the actions. Okay? Personally, I don't think it's going to be a problem.
Got it. And sir, just one other thing. I've seen other applicants or other questions about applicants filing a fresh I-485. Is it a better option?
No, right now, interfiling is the better option because you have that special address where you will send it. Okay. USCIS has given a separate address for supplement J interfiling requests. So yeah, I would do an interfiling if I were you. Okay.
Got it. Thank you so much.
You're welcome. Area code 979. Where are you calling from? 979.
Hi sir, I'm calling from Dallas, Texas.
Okay.
So my question is, if my H1B gets picked in the lottery through a company which I'm working with now currently,
Right.
what is the earliest I can transfer it to a new company?
Well, the way I would do it is, if I were in that situation, first of all, it is safest to do it once you are past October 1st. Okay. And ideally 1 or 2 pay periods after you have the H1B approval. That would be one way to do it. Another way to do it is if you really get a better job offer and your existing employer says, okay, that's all right, you can move, we won't revoke your H1 until after October 1st, then you are okay too. Okay. So either wait until a couple of pay periods after you get the H1B approval and you have been on H1B status, which is October 1st, or see if the employer will not revoke your H1B before October 1st. All right.
Okay.
Good luck.
Thank you.
You're welcome, sir. Area code 917. Where are you calling from?
Hi, Rajiv. I'm from New York.
New York. Okay.
And thank you for the community.
Absolutely. My pleasure.
My question is, my wife's last name in her Indian passport and then green card is different. She has the old married name in the Indian passport and the new name in the green card. And she got divorced in the US.
Okay.
Does that pose a challenge traveling to India? And
Not usually, because she'll have a divorce decree that gives her name. But another way to do it is, this is what I'd recommend to all my clients. I say choose a name you want to keep. Then just go to the local court and ask the district court to give you an application for a name change. Do your official name change and then accordingly correct all your official documents. On the US side, that's a perfect solution. On the Indian passport side, you might have to check with the Indian passport authorities if that is acceptable and how difficult it is to change her name then. But on the US side, that's a perfect solution. However, if you can, through official documents, correlate the chain of names, traveling should not be a problem. It could take a little time to get back into the United States. You might have to go through secondary inspection, but it's not illegal. It's fine.
Oh, perfect.
Right.
No, she on the US side, she did get when she got married, she went through that legal process for the name change.
Right.
So she got her social security, green card, etc. on the new name.
Well, it can be done more than once, right? So if you wanted to do it again, you could.
Okay.
Good luck.
Thank you very much.
You're welcome. Okay, then we have a question from Virginia. So Virginia, your name looks familiar. Hi, good afternoon. Go ahead with your question.
Yes, so I have a question. So I downgraded from EB2 to EB3 in October, got EAD.
Right.
And now I've got this message and the notice from USCIS that my case has been transferred to new office, which is NBC. And my date is not even current. My date is June 2012, and the current PD is I think January.
Okay.
So what does that mean?
I'm not sure. There could be two reasons. One, obviously, is the work redistribution. So sometimes USCIS redistributes pending cases based upon the workload of each processing center. So if I were you, I would just call them up and find out. Not a bad idea. Might take you all day to get through, but it's worth it. Find out why did they transfer your case. Okay.
Yeah, I mean they said in the letter that to speed up the process.
Yeah, so that means it's work redistribution. Yeah, it's just work redistribution. Okay.
Okay. Yeah.
Good luck.
All right. Yeah. Thank you.
And the last question for the day is from area code 813. 813, where are you calling from?
Hello, Rajiv sir. I'm calling from Florida.
Yes, sir. Go ahead.
So my question is, I'm doing a Master's of Cybersecurity course from St. Leo University in Florida, and I'm in my second semester right now.
Okay.
So I'm applying for an internship. I spoke to my DSO about that.
Okay.
And for some strange reasons, she keeps telling me that if I do a CPT for more than one semester, chances are that USCIS might deduct some time of my OPT.
That's correct. That's correct. What I want you to do is just go to this website called studyinthestates.gov. So just Google it. Google one word, study in the states. Okay. I'll tell you why I like that site very much. This is a site that is maintained by the government, and this site has information for both the DSOs as well as the students. So you can see what the DSO do. They show you screenshots on how they update the service system, and you also have information for students themselves. So go to service and read up on optional practical training, how they will deduct time if you have used CPT before graduation. It's a very, very easy to find information from that site. Okay. Studyinthestates.gov.
So, sir, but somewhere I've read that you can continue CPT for 1 year and still be eligible for full-time like OPT for 1 year and same extension for 2 years.
I just gave you the answer. I'm not sure about what the exact rule is, but definitely there is a deduction beyond certain number of months. Okay.
Okay, so I'll go to the site and I will...
look it up, and otherwise you can always contact me if there's a problem. Okay?
Okay, sir. Thank you so much.
You're welcome. Good luck. Okay, folks, so we are done for the day. It's always a pleasure to talk to all of you. I'll see you again in 2 weeks. Take care, guys. Bye-bye.